The second of those periods, between 1995 and 2005, changed because of the third-party representation rights in the Industrial Relations Commission. As I said earlier, in that period it became very difficult for the community to provide third-party oversight of industrial agreements. In effect, the court was limited to approving new rosters where an employer and an employee had come to an agreement. In the past, even though there was agreement between the employee and the employer, the commissioner might ask on behalf of the community, I know you're all agreeing to it, but is it safe? That became very difficult post-1995, and as a result, in my opinion at least, many of the rosters that were voted in by agreement between employer and employee took little account of what we know from the science about the likely fatigue-related risks associated with those patterns of work. We've seen some other changes in the industrial relations landscape in the last couple of years, and in the period 2005 to now, we've seen the issue of extended commutes arise very significantly. This has been particularly associated with the mining boom, where large numbers of employees are now flying in from not only all over the state or all over the country, but in some cases internationally. And in many cases we find people getting off a commute of 12 to 13 hours to go straight to work. Again, one of the issues is that while this provides significant microeconomic reforms and productivity benefits to the companies in not having to establish towns, in terms of employees being recruited from all sorts of areas where they take money back to spread the benefits of that boom, in many cases the consequences of these changed work practices in terms of what the impacts on fatigue are have not been well thought through. We'll talk about more of that a little bit later. But one of the important things to understand in terms of this course is that in the period 1985 to now, we have seen a gradual dilution of the capacity of the industrial relations system to effectively control fatigue as a hazard. In the past, we used to have the 8-hour day, and then it became the 12-hour day, and for some people now it's close to a 16-hour day. But in the past, we were able to use the industrial relations mechanisms, enterprise bargaining agreements, award conditions, as a method of controlling how many hours people worked, and using that as an indirect mechanism to control the likelihood that people will be fatigued. As a result of those microeconomic reforms, the capacity of the industrial relations systems to manage fatigue has been significantly diminished. Now, on one level, you may think that's a good thing, or on another level, you may think it's the end of life as we know it on the planet, and that will to some extent reflect your politics and your ideological beliefs around who should control working hours and whose responsibility that is. But it's very clear that in that period from 1985 till now, the primary mechanism that we had for managing fatigue-related risk, that is regulation of working hours, has unravelled as a control mechanism. Now, some people will argue that even in the past it didn't manage it particularly well, and there is some truth to that. But it is really clear now that particularly in the last 10 or 15 years, employers and employees have been able to negotiate changes to hours of work, individual contracts or EBAs, that don't require them to comply with any occupational health and safety requirements. In many cases, this is because the employers and the employees are negotiating this at the local level within the organisation, and that leads to evidence-free policy in many cases. What we have seen, however, over the last decade is that as the industrial relations mechanisms have diminished their capacity to manage fatigue, then that slack has to a certain extent been picked up by occupational health and safety regulation. So what we've seen over the last 20 odd years is a shift away from the use of industrial relations mechanisms for managing fatigue-related risk, and a shift towards use of the occupational health and safety system as the primary regulatory control. And if we look across most of the jurisdictions in Australia, we will see that fatigue has become an identified workplace hazard starting in around about the early 90s. And by 2005, every state in Australia had identified fatigue as a workplace hazard. The other big shifts we've seen are that we have moved away from the notion of compliance-based regulation, that is, thou shalt work so many hours, thou shalt have breaks of a certain minimum duration or frequency, to one in which it's being approached under the general principles of risk and safety management. As we talked about earlier, this has been a very critical developmental phase because we have realised that from a risk management perspective, not all rosters are equal. You can have a 12-hour shift on the photocopier or a 12-hour shift landing a jumbo jet, and we need to think about managing the risk. I think it's also worth thinking about the general shifts within occupational health and safety for all hazards. That is, in the last 10 or 15 years, we have seen risk and safety management emerge as general principles around the management of occupational health and safety. That is, starting with Robins in 1972 in the UK, we have seen around the English-speaking world a massive shift away from compliance-based approaches to what have been referred to as performance-based approaches to regulation. And I think this is no different for fatigue. In the same way as we have seen the principles of risk and safety management and the Robins principle of the firm being the most appropriate point at which to manage risk, we've seen that principle applied equally to fatigue as to many other hazards. I think we're going to see that same principle emerge over the next 5 to 10 years, and we will see increasingly that organisations will be required to manage the risks associated with fatigue. And you can see that shift in the way that people talk about their policies within the organisation over the last 5 or 10 years. When I first started in this field, people would talk about their fatigue policy, then it was their fatigue management policy, and then more recently they talked about fatigue risk management policy. And it's very important to think about this from an occupational health and safety perspective. The Act requires you to take all reasonable steps to minimise the risk associated with a given hazard. It doesn't actually require you to eliminate fatigue. And we'll talk a lot about this in the second part of the course, but I'll often say to organisations, it doesn't matter whether people are tired unless that poses a risk. Your job is to manage the risk, not to manage fatigue per se. This is a really critical point and one that is absolutely essential for you to understand as we go forward into the operational management of fatigue-related risk within the organisation. The third point that I'd like to make in terms of the political context around fatigue is a number of recent parliamentary inquiries. Back in 2000, the Parliament ran an inquiry called Burning the Midnight Oil, and that was a parliamentary inquiry into fatigue in the transport industries and looked primarily at road, rail and aviation, but also took submissions from another number of other industries including mining, healthcare and emergency services. What was very important in that particular parliamentary inquiry was the parliamentary decision to move away from compliance-based regulation. There had been an enormous amount of discussion during the inquiry about whether we should bring back or reinforce the use of regulatory principles around limiting working time in order to manage the risk. And I think when the history of fatigue management is written in 20 or 30 years from now, a number of key points will emerge, and one will be the findings of that Australian parliamentary inquiry. At the time they said there isn't sufficient evidence to justify the limitation of working time arrangements as the sole method of control. And the amount of diversity in the Australian workplace is now such that we don't believe there is a single solution approach that can be put in place. That parliamentary inquiry recommended 3 key aspects of fatigue management that they thought would be critical to shape the landscape going forward, and they were that fatigue-related risks should be managed under a risk and safety management framework, and they further reinforced that it was critical that all of the occupational health and safety regulatory agencies around Australia, including Safe Work Australia, introduce and clarify the fact that fatigue is an identifiable workplace hazard for which employers and employees both have responsibility. This last point will be critical to the rest of this course, and it raises a number of very interesting theoretical issues. But the first is that the majority of hazards in workplace are seen as primarily the responsibility of the employer. The employer introduces you to a hazard such as hazardous chemicals, and it's their responsibility to provide you with personal protective equipment and those kind of things. Fatigue is unlike other hazards in the sense that many of the causes of the hazard originate from outside of the workplace. And I think one of the critical discussions in the parliamentary inquiry and in subsequent occupational health and safety legislation from a political perspective has been the introduction of the idea of self as hazard. What do we do in the event that the individual themselves are the hazard as distinct to some external agent or chemical or source of energy? And I think the parliamentary inquiry was to be congratulated, because what they did was to say, actually, we need to manage fatigue as a shared responsibility. There are certain aspects of fatigue for which the employer is responsible, but there are equally a very significant number of issues for which the employee is responsible. We'll take that point up in considerable detail later in the course, but in simple terms, I think it's very worth considering what the implications of this are. That is, what happens to an individual outside of work can potentially influence their fitness for duty at work. If I've been up all night with a sick kid, or I've been out on the terps, I can turn up to work the prescribed shift duration, but have had little or no sleep in the prior 24 hours. How do I actually manage that from a legal perspective? Whose responsibility is it to ensure that you get sufficient sleep? And I think what's important in the parliamentary inquiry is they argued, and I think quite successfully, that part of the issue here is that we need to be very clear that employees have a responsibility. If you think about this from a legal and political perspective, there is a statutory responsibility. If you look under Occupational Health and Safety Acts around the country, you have a statutory responsibility to identify a workplace hazard. If you yourself are the hazard, that doesn't preclude your responsibility to identify it. We're going to pick this point up in a lot more detail later, but before we do that, I'll talk about the last parliamentary inquiry, which was the recent parliamentary inquiry on fly-in, fly-out and drive-in, drive-out work practices, particularly in the mining industry. They identified extended commute times, which we talked about a little bit earlier, as one of the key factors that we need to think about in terms of fatigue-related transport. Some work that's been done up in the Bowen Basin in recent years shows that you are 60 times more likely to have a fatality driving to and from work than being underground at work. There's been a large number of fatalities in the Bowen Basin over the last decade or so, many more than we've actually seen in the mines. And for those guys who work in the mines and drive 5 or 6 hours after a night shift to go back to the coast, we need to think about what the implications are for that and how to manage that. And sometimes that's not easy, because in many cases people want to assume the risk. What the challenge for you as a manager within an organisation or as an employee undertaking risky behaviours is to work out for what am I responsible and for what is the organisation responsible, and how can I minimise the risk both to the organisation and myself. But more of that later.